To be honest, there have been many times in which I have been close to lose my faith in international law, because victories in international law, palpable victories, are scarce, and whenever there are victories, they come just in the form of first downs and never as touchdowns. However, as my former supervisor at the Ministry of Foreign Affairs used to say, international law must be regarded as a marathon, not as a 100 meters hurdles. That proverb changed my life completely, and it changed my perspective on international law, and that's the perspective that I want to share with you today. The world has always been in conflict, but international law has never been stronger, in my opinion. During these next 11 or 12 minutes, I will try to convince you about the strength of international law through the following 5 ideas. I can only touch these ideas rather briefly, but we can discuss them more deeply during the Q&A session if that's what you want. So let's start with the first idea. Critiques of international law are not new. They have always existed, and they will always exist. Just like the far, far away galaxy in Star Wars was divided between the Empire and the Rebel forces, international law theories have always been divided into two irreconcilable theories: realists and institutionalists. The first endless debate between these two theories has been over the nature of international law itself. While realists claim that international law is not positive law because it lacks coercion, institutionalists have argued that they reject that coercion is the basis of international law, or a positive law, and that there are many reasons why people comply with international law. So they reject it completely. The second debate between realists and institutionalists has been over the influence of international law over the state's conduct. While realists claim that international law does not define the conduct of states, for instance, President Trump, during his inauguration speech last January 21st, 2017, he claimed that we will seek friendship and goodwill with the nations of the world, but we do so with the understanding that it is the right of all nations to put their own interests first. From this statement, we can infer that his administration will be guided by realist principles, because realists, in the realist perspective, they're utilitarians in one form or another. States seek to maintain their power, their position, and their wealth, and they use only international law as an instrument to attain their interests. So this argument allows me to infer that his administration will be guided by realist principles. On the other hand, institutionalists claim that international law does define the conduct of states. And for instance, President Barack Obama, during his last speech before the General Assembly of the United Nations, claimed that we have bound our power to international laws and institutions. I believe that as imperfect as they are, the principles of human rights and international law remain the firmest foundation for human progress in this century. This statement, I think, allows us to infer that his administration was guided, at least in theory, by institutionalist principles. But these are just two of the many debates that have been discussed between realists and institutionalists. They have always existed, and they will always exist. So let me move to the second idea. Patience is the key element to appreciate the enforcement of international law. In the past few years, it seems that realists have attracted more young people into the dark side than institutionalists have attracted into the force. And the only explanation I can find about why people is losing their faith in international law is the same that explains why many people are losing their faith or their interest in baseball, and that's millennials. We millennials are members of a generation that have lost completely the virtue of patience. For millennials, waiting 2 minutes between pitches is tantamount to serving life sentence. If we cannot wait 3 hours to watch a complete baseball game, we're less likely to wait for 3 years or decades to see the enforcement of international law. We are a generation that demand instant results immediately. However, instant gratification comes at a price, and that is that we're losing our patience. And international law demands a lot of patience, particularly because the life cycle of international norms It's a three-stage life process. It takes norm emergence, norm cascading, and norm internalization. And none of these stages is assumed to occur automatically. It takes years, and we must be patient. And even though I will be the first to concede that international law process can be exhausting, patience pays off. And just as Master Yoda would say, patience you must have, my young Padawan. So it's important to have patience in the process of international law. The third point, the enforcement of international law is different from the enforcement of domestic law. We almost always only see the spectacular failures of international law. The annexation of Crimea by Russia, the invasion of Iraq by the United States, are only two of the many examples that critics of international law used to argue that international law is useless. But to argue that international law is useless just because it was not able to stop the annexation of Crimea, it is as useless as it is as ridiculous as stating that criminal law is useless because it has not been able to stop the homicides in the whole world. Theories of punishment give us an idea of what I'm trying to explain. The theories of punishment explain that punishment deters people from committing the crime. They are the general deterrence and individual deterrence. If you want, we can go a little bit deeply during the Q&A session. But in this sense, in general, the murderer ponders if the fear of prison is bigger or lesser than the desire to kill. And in that same sense, Russia considered that the value of invading Crimea was greater than the cost of enduring any political, economical, or armed countermeasure. So we cannot argue that international law is useless because it has been unable to stop or prevent any of these cases. Moving to my fourth point. Every country implements international law in very different ways. And let me start using this analogy. International law critics make the same mistake that football commentators do. When football commentators make an analysis of La Liga Española, for instance, they only make their analysis in terms of what Real Madrid and Barcelona have done. They don't pay any attention at all to the less popular teams. Whenever they pay attention to the less popular teams is when they face Real Madrid or Barcelona. And the same thing happens with international law. Whenever international law critics argue about the uselessness of international law, they are only referring to the big giants, to the superpowers of the New World Order, according to Henry Kissinger. The United States, Russia, Europe, China, Japan, India. But we cannot judge a forest just by staring at 6 of its trees. The Family of Nations has 193 members, according to the UN. And there are many countries that have made phenomenal advances in international law, but to whom nobody is paying attention because they don't belong to the superpowers club. For instance, Mexico. Mexico, we were talking briefly about it yesterday, but in 2011, it passed a constitutional reform to Article 1 that placed human rights treaties in the same hierarchical position of the Constitution. It also reformed Article 1 to establish the principle of pro hominem, which signifies applying the greatest protection for the individual in accordance with the Constitution and international treaties on human rights. And after this reform was passed, the Mexican Supreme Court resolved that all judges at all levels have the ability to declare a domestic law or act unconstitutional in accordance with the American Convention. This was a great success. It was a great advance. But nobody in the international community paid any attention, just because Mexico does not belong to the superpowers club. But just imagine how big or what the consequences would have been in the United States if a reform with this magnitude had been approved here. It would have been amazing. So, final but not least, I want to argue that international law must not be confused with multilateralism or economic integration. It is undeniable that populist movements all over the world have threatened globalization and multilateralism. Nationalism rising in Europe and the United States have urged the governments to propose new solutions to their populations. In Europe, for instance, the United Kingdom voted to leave the European Union, and here in the United States, President Trump has promised to renegotiate or withdraw from NAFTA. However, these examples, these cases, are not examples of the fragmentation of international law. On the contrary, these cases prove the strength and power of international law. The international law is so strong that even when the countries decide to isolate themselves, they have to do it through the means of international law. For instance, the United Kingdom has had to trigger Article 50 of the Lisbon Treaty to withdraw from the convention. And if President Trump wants to renegotiate or withdraw from NAFTA, it would have to be done pursuant Article 2202 or 2205, respectively, of the NAFTA Convention. So this proves that the relevance of international law, not its fragmentation. It's important not to confuse economical integration with international law. So in these few minutes, I've been trying to explain these 5 points. I'm sorry if I don't have any punchy conclusion, but it had to be sacrificed in order to finish in only 10 minutes. Thank you very much.